We're getting ready. We're getting ready, people. Good morning, good afternoon, and good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, here's one of my quick review videos, addendums to this Diddy information that we got. So please, housekeeping, please hit that like button. Please share this video if you care. If you want to support me for the free, hit the like button and subscribe. Once you subscribe, you'll be open to a plethora of movies and television series that I have reviewed and my pop culture chats. Also, if you want to support this channel monetarily, hey, memberships are available, and my Cash App is scrolling on the bottom of the screen. All right, people. So what I wanted to go over today is that I wanted to read the initial letter to the judge for the bond request from Diddy's camp, because we went over the indictment. And so now I want to go over the bond letter, that the initial bond letter that Diddy's defense had written and submitted to the judge. And then I'm going to come back and read the letter that the prosecution, and it's going to be a whole nother video. So each one of these is going to be their own separate video because of the length of these documents. And we're going to read them and put them in. Okay. Again, please like, comment, and subscribe. Let's get to it. Let's get to it. Let make me smaller. Let me see how I want this. Nah. Nah. I like this. All right. So let's get to the letter. Let's make it bigger. So it is 10 pages, and we're going to read all 10 pages. I just want to be able that you all can see this letter as we read it. That I think that's good enough for us to see it. All right. So this is from Agnifilo Intrator, and this is Sean Combs' lawyer. It says here VIFECF, the Honorable Robin F. Tarnowski, United States Magistrate for the Southern District of New York, where it's staying. This letter was written on September 17th. And this is regarding the United States versus Sean Combs. And it says, Dear Judge, Mr. Sean Combs, through his counsel, submits this letter to the court for release on certain specified conditions. Yesterday evening, Mr. Combs was arrested on an indictment and charging him with the following offenses, and they list them all. We're not going to go through that. For the reasons set forth below, we ask that this court release Mr. Combs pursuant to our proposal bail package. This letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that will prove that he is not a risk of flight or a danger to anyone in the community. These actions prove that Mr. Combs is eminently trustworthy, and he is demonstrably committed to show his innocence in court in the context of this case, and that he should be released on the conditions proposed in orders to do so. The first thing the court should know is that when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary. He left his home in Miami and traveled to New York, the very location of the prosecution and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. Even though Mr. Combs came to New York, authorized his lawyers to tell the government of his location, and offered to surrender, the government effected an arrest last evening. This, we know, is the government's right. However, he traveled to New York to self-surrender, also something the court should consider. This was not the first action Mr. Combs took to show his trustworthiness and lack of flight risk. Indeed, it is part of a pattern since even before the March 25th, 2024 search on Mr. Combs' residences. Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking and other offenses. Knowing for these many months that he would be indicted, Mr. Cohn has done everything, as will be set out below, to work with prosecutors in ways that are unusual, if not unprecedented. He's buttering us up, isn't he? Let's continue. In light of the circumstances, he can the presumption of detention here due to his extraordinary actions in this investigation. Mr. Combs should be released on the condition proposed so that he can fight his case in court effectively. So here's the proposed package, because I had given you pieces of this proposed package on another video. The defense proposes the following bail package: a $50 million bond, co-signed by Sean Combs, his mother, his sister, the mother of his eldest daughter, and 3 adult sons, secured by the equity in Mr. Combs' residence located at 2-Star West Star Island in Miami, Florida. The appraised value of the home is about $48 million. The home is unencumbered. Excuse me. Excuse me, y'all. The home is unencumbered in anticipation of this bail hearing on August 20, 2024. Mr. Combs paid off the remaining mortgage of about $18 million so that the home could be used to secure a bond and be free of a mortgage. Secured by the equity of Mr. Combs' mother's home located at 450 Alton Road in Miami, Florida, Mr. Combs' travel will be restricted to the Southern District of Florida and the Southern District of New York to attend court meetings, meet with his counsel, and to attend medical appointments, which will address to the court in a separate sealed submission, as well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves airports in those districts. Mr. Combs' passport was surrendered to his counsel on April 1st, 2024. His counsel advised the prosecutors of this fact in an email dated the same day. Counsel will provide this passport to pretrial services. The passports of the following family members who have already surrendered their passports to counsel after the raids on Mr. Combs' home. Now, this is where I just find to be I don't know. I don't know why the family would have had to surrender their stuff unless they are considered to be witnesses or parts of this suit. So you have his mother, Janice Combs, his daughter, Chance Combs, his twins, Jesse Combs and Delilah Combs, and Love Combs, I think, is a baby. See, all of these, with the exception, I think, of Janice and Chance, because I think Chance may be 18, but the rest of the girls are children. And why, let me see, because I'm not seeing where his sons have surrendered their passports. Isn't it interesting that all the women in his life have surrendered their passports, but none of the men in his life have surrendered theirs? But let me go down to see if there's anything going on, because this is the complete document. Since at least April 2024, Mr. Combs has been making an effort to sell his airplane. We informed the government of these efforts in May 2024, as explained further below. Just this weekend, Mr. Combs entered into a letter of intent with a party to sell it. Mr. Combs understands he is not to travel to Los Angeles, where the plane had been located this week, and further that the plane is not to be brought to any district in which he's located until it's sold. Well, if once it's sold, anyway. Home detention with GPS monitoring and all other standard conditions of pretrial supervision. All right, so let's see. The history of, what do y'all think so far? Put it down in the comments for me. The history of this investigation shows a great degree of collaboration between the government, Mr. Combs, and his counsel, which should weigh heavily in this court's releasing him on the conditions proposed. On March 13, counsel for Mr. Combs emailed the assigned assistant United States attorneys. In this introductory email, counsel identified himself as counsel for Mr. Combs and stated that he wished to speak with the prosecutors and share information about Mr. Combs and the matters under investigation. And they say, see exhibit number 4. After not hearing back from the AUSA, Counsel again emailed the prosecutors on March 18th. Counsel did not get a response to this second email either. On March 25th, search warrants were executed at Mr. Combs' place of residence in Miami and Los Angeles. In addition, he was removed from his airplane and searched. The searches of the residence were unusually public and particularly heavy-handed. The agents had assault rifles trained on the heads and the chest of his children, who were then handcuffed and brought before news cameras and press helicopter. We remember that. On the day of the searches, counsel called the prosecutors and they spoke for the first time. Counsels indicated that he would accept services of 2 grand jury subpoenas to Mr. Combs' businesses. So let me stop here. Hold on. Thank y'all for y'all patience. Me and these allergies are going through some stuff. Counsel took possession of Mr. Combs' passport on April 1st, 2024. About a week following the searches on April 1st, counsel took possession of Mr. Combs' U.S. passport, as noted. On the same day, counsel advised the UASA of that fact, that Mr. Combs' passport, that we would not return it to him and that he would not leave the country during the pendency of the investigation. See Exhibit 1. We have, in fact, maintained the passports, and Mr. Combs has not, in fact, left the country despite knowing the investigation was ongoing, despite having a plane at his disposal, despite not being charged with any crime. And it says here, as in the footnotes, as of this morning, the plane is in Teterboro, New Jersey for a charter flight. Number 2, counsel agrees to advise the government of all domestic travel. Moreover, counsel advised the government that if Mr. Combs intended to travel domestically, counsel would so inform the AUSA. These 2 promises have also been kept. For example, on June 9th, 2024, counsel advised the ASUA that Mr. Combs was traveling from Miami to Los Angeles to go on a road trip with his children. See exhibit number 5. In addition, we provided the AUSA with the information about when his flight departed and when it would land. On June 29, 2024, counsel emailed prosecutors that Mr. Combs was flying to Wyoming via a chartered aircraft. See Exhibit 6 at 3. At number 3. On July 5th, 2024, counsel emailed prosecutors that he was traveling back to Los Angeles. 2 days later, on July 7th, when he traveled back to Miami via a chartered aircraft, we again emailed the AUSA at ID at 2. In addition, when Mr. Combs planned travel, but not take those. In addition, when Mr. Combs planned travel, but not take those trips, we notify the prosecutor of that as well. So additionally, when he was planning to travel and then he did not take those trips, they alerted the prosecution. Number 3, counsel advises the government of Mr. Combs' effort to sell his plane. On May 21st, 2024, counsel advised the AUSA during a phone call that Mr. Combs had commenced efforts to sell his airplane. We followed up on that conversation the next day on May 22nd, 2024, with a letter to the AUSA that efforts were underway to sell the aircraft and reminding the AUSA that counsel continued to be in possession of his passport. Over the past several months, we had several potential buyers for the airplane, and at least 2 buyers have signed a letter of intent to purchase the aircraft. Just this weekend, a buyer for the aircraft and representatives for Mr. Combs executed a letter of intent. Due to the nature of this asset and the amount of inspection and due diligence as required for a purchase, it is not a simple asset to offload. In advance of the plane being sold, which it eventually will be, we have agreed to keep the airplane in Los Angeles while Mr. Combs resides in his home in Florida. If it's not being chartered, coincidentally, and not at Mr. Combs' request, last night, the airplane was chartered on a Part 135 flight from Los Angeles to Teterboro, New Jersey. Mr. Combs has no advanced knowledge of the flight, nor did he possess any control over its movements last night. Obviously, Mr. Combs agrees to not to go to any state, in this case, New Jersey, in which his airplane is located pending its sale, which is actively being pursued. So he's trying to sell. He's trying to offload that plane. They're not saying how much he's trying to offload that plane. I don't know if that's pertinent to what the prosecution needs to know, but that is interesting. It says here, Mr. Combs voluntarily relocated to New York in advance of his arrest. Once it became apparent to counsel that Mr. Combs' arrest was imminent, he promptly relocated to New York City on September 5th, 2024. Mr. Combs arrived in New York and counsel immediately informed the government of Mr. Combs' whereabouts. Counsel offered to continually share Mr. Combs' location with the government. Since arriving in New York on September 5th, Mr. Combs had been staying at the Hyatt New York due to bookings made at the Park Hyatt prior to Mr. Combs' reservation. After today, September 17th, he would no longer be able to stay at the Park Hyatt. According to Mr. Combs, had a reservation to stay at the Carlisle Hotel starting today. So it says here, I just want to be clear to read the little notes right here. Pursuant to the Code of Federal Regulations, Part 135, a private jet may be available to the general public for use. Part 134 pertains Mr. Combs' airplane and therefore can be chartered by the general public. So he's making money by chartering the plane. Let's continue. We're doing good. We're halfway through this letter. We're on page 5. Since Mr. Combs relocated to New York earlier this month, counsel has been looking for a 1 month rental for Mr. Combs in New York City. So he does not live in New York anymore. So he has vacated New York. Because that's what was interesting to me, because I thought he had a place in New York. So currently he has vacated New York, and Florida is his home of residency, and he just goes back and forth to New York. Interesting. Let's get back to the letter. Despite counsel's persistence, it has been challenging to find a rental for many reasons, including because of the numerous events occurring in New York City in September, aka the U.S. Open, Fashion Week, and the UN Summit, and some landlords' discomfort with having Mr. Combs as a tenant, given the investigation. Last night, counsel has scheduled a viewing of potential apartment. However, because of Mr. Combs' arrest, counsel and Mr. Combs obviously were not able to view the rental. Duh. I'm sorry. But it looks like you would have had that set if you knew you were going to come back. This is just my opinion. You knew you were going to come back. I don't know why it was so difficult to find a place in New York City. I'm quite sure even in the neighboring county, I think that he could have found a place, but that's just me. Counsel advised the government that it was in possession of the passports of a member of Mr. Combs' family. Now, this is interesting because I'm trying to figure out what the purpose of this was. On June 13th, 2024, counsel informed the government that we possess Mr. Combs' mother's passport. We have also informed the government that we possess the passport of his 4 daughters, all of whom were minors at the time we took possession of the passports. Okay. Because I'm trying to figure out, well, with the exception of the twins, the other girls have their mother there. Why couldn't their mother be in possession of their passports? Anybody in legal team, y'all put that down in the comments or let me know, because I'm very interested to know that. Uh-oh, we went too far. Where are we? We're on page 6. We're supposed to be on page 5. I really would love to know that. Number 6, counsel's assistance to the government concerning the subpoenas. As stated above, counsel accepted service of 2 subpoenas directed at several of Combs' businesses in March of 2024. Separate counsel for the entities filed a motion to quash those subpoenas in April of 2024. In May of 2024, upon becoming the sole counsel in connection with the criminal investigation of Mr. Combs, we advised the court that it would withdraw the motion to quash the grand jury subpoena and instead that the parties would meet and confer with the government to minimize the number of requests on which the parties disagreed. Counsel agreed to begin gathering documents responsive to the subpoena. For the past several months, counsel for Mr. Combs and the AUSA have had regular discussions about what documents we had, what we did not have, in regards to the documents that we did not have, where the government may be able to find such documents. We did this for two reasons. First, there was nothing in counsel's estimation that would constitute evidence of Mr. Combs being involved in any federal crime. Second, we wanted to be appropriately helpful to the government in its investigation. To that end, Combs entities have produced over 144,000 pages of documents to the Southern District of New York in compliance with the subpoena. And down here, the confirmation number for this reservation is whatever. Counsel will provide additional confirmation upon request. That must have been for them trying to see that rental. Let's go to page 6. Paying off the mortgage of the 2 West Star Island in Miami. As noted in the discussion about the bail package, on August 20th, 2024, Mr. Combs caused the outstanding mortgage to be paid on his primary residence in Miami. This payment of about $18 million for one reason alone, so that he would have this $48 million residence free and clear of any encumbrances so that it can be used to secure a bond. We submit that this is a truly extraordinary measure that shows resoundingly that Mr. Combs is appropriately focused on defending this case on the merits in this court. Legal standard. Because Mr. Combs is presumed to be innocent, the Supreme Court observed that liberty is the norm and detention prior to trial or without trial is carefully limited exception. And they go into the United States versus Salerno, all the little different things. As Supreme Court recognizes, the function of bail is limited. They talked about a Supreme Court case, Stack versus Royal. The underlying goal is securing the presence of the defendant rather than the sum of bail. United States versus Nibia. When deciding an issue of pretrial release, the Second Circuit has noted that the court should bear in mind that it is only a limited group of offenders who should be denied bail pending trial. United States versus Shakur. Indeed, the bail reform requires that court impose the least restrictive conditions or combination of conditions that will reasonably ensure the appearance of a person as required and the safety of the community. While there is presumption of detention in the trafficking cases, this presumption is rebutable. The presumption imposes on the defendant a burden of production, while the burden of persuasion remains with the government. United States versus Mercedes. Although this burden is not heavy, the defendants must introduce some evidence contrary to the presumed fact. United States versus Rodriguez. A defendant can satisfy this burden by coming forward with evidence that he does not pose in a danger to the community or risk of flight. Even if the defendant presents some evidence satisfying his or her burden, the presumption favoring detention does not disappear entirely, but remains a factor to be considered among those weighed by the district court. ID in Jessup, the benchmark case defining this burden the court explained. And then they go to read this, and we're going to read it. Since the presumption is but one factor, Since the presumption is but one factor among many, its continued consideration by the magistrate does not impose a burden of persuasion upon the defendant. And since Congress seeks only consideration of the general drug offender flight problem, the magistrate or judge may still conclude that what is true in general is not true in the particular case before him. He is free to do so and to release the defendant as long as the defendant has presented some evidence and the magistrate or some judge has evaluated all of the evidence with Congress's view of the general problem in mind. So basically, they're arguing that even though he has these charges, this is just Pam. I'm a layperson, so I'm just going over what I think, what I read. Even though he has these charges going up pending of him, he has shown himself to be trustworthy to remain free. Hmm. That's what I get out of that. So let's go to page 7. Let's see. Right. All right. So we're trudging along. Acknowledging that sex trafficking has a rebutable presumption of detention, Mr. Combs can rebut such a presumption with evidence that he does not pose a danger to the community and is not a flight risk. So they're saying because of this, him, I guess basically he's no longer. Let me not presume nothing. Let me not presume nothing. Let me just continue to read it. I told you I was going to read the information to you all, and you all make a conclusion on your own. That number one. So this is section 33142G factors. So number one, the nature and circumstances of the offense. Mr. Combs is charged with 3-count indictments. The first count charges Mr. Combs with a racketeering conspiracy in violation of 18 USC 1962D, count 1. Count 1 alleges that Mr. Combs relied on the employees, resources, and influence of multifaceted business the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in an attempt to and attempted to engage in, among other crimes, ex trafficking, forced labor, kidnapping, arson, bribery, obstruction of justice, and the conspiracy lasted from at least or on about 2008 through the filing of this indictment. And you remember I said in my other video that now we see the time frame in which they're looking at, and they're also going to the filing of this indictment, because you remember they denied his bond because of the fact that they felt like he was doing some intimidation or talking to witnesses and things like that up until the time that they had the hearing, or up until the time that he was arrested. As alleged, the pattern of racketeering consisted of A, multiple acts involving kidnapping, violation of California law; B, multiple acts of arson. Multiple acts. I knew about the alleged Kid Cudi incident, but this says multiple acts of arson. Who he burning down? Whose houses have burned down? Multiple acts of arson in violation of California law. So this happens in so these arson charges are stemming from California. This is interesting. Was Kid Cudi's car in California? Was that where this incident happened? This is interesting because it says multiple acts of arson. Hmm. In violation of California law. Multiple acts of bribery, multiple acts involving bribery in violation of California law. Multiple acts indictable under 18 USC 1512 relating to tampering with a witness or informant. Multiple acts indictable under 18 USC 1589 and 2 relating to forced labor. Multiple acts indictable under 18 USC 1591 and 2 relating to trafficking. Multiple acts under 18 USC 2421, 2422, and 2 relating to transportation and inducement to travel for purposes of tooting and other illegal sexual activities, and multiple offenses involving the possession with intent to distribute or distribution of narcotics and controlled substances, including but not limited to cocaine, oxycodone, alprazolam, methylene dioxymethamphetamines, brono, uh, dimethylphetamine, whatever that is, and gamma hydroxybutyric acid and ketamine. So these are the medications in violation of 21 USC 841A1 B1C, B1E, and B2. And 846, distribution and possession with intent to distribute and conspiracy to commit the same. Aiding and 18 USC 2, aiding and abetting and willfully causing. I read that wrong, but let's continue. Indictment 13, one count also includes a notice of special sentencing factor in connection with Mr. Combs' alleged agreement that means of force, threats, or force, fraud, and coercion would be used to cause the person to engage in a commercial sex act. The second count charges Mr. Combs with sex trafficking by force in violation of 18 USC 1591A 1, B1, 1954A and 2. Count 2 alleges that from at least in or about 2009 up until including about 2018, Mr. Combs recruited, enticed, harbored, transported, and maintained a person, victim 1, and attempted, aided, and abetted, and willfully caused victim 1 to engage in commercial sex acts known and in reckless disregard of the fact that victim 1 was engaged in commercial sex acts as a result of force, fraud, and coercion. The third count charges Mr. Combs with transportation to engage in prostitution, violation of 18 USC 2421 A and 2, count 3. Count 3 alleges that from in or about 2009 up into including in about 2024, Mr. Combs transported, aided, and abetted, and willfully caused the transportation of female victims and commercial sex workers in interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. Indictment. The indictment also includes forfeiture allegations pursuant to 18 USC 1962, 1594, 2428, and 981A1C, and 28 USC 2461, indictment 18 through 20. So then getting down here, and we're getting down to the last little nitty gritty of all of this. Again, please like, comment, and subscribe. Please share this video if you care. If you're interested in also having me to read some other information, I am more than happy to do so. Mr. Combs' history and characteristics are best demonstrated by the way he has responded to this investigation from the very inception to his most recent decision to travel to New York when his lawyers told him that the case would soon be starting. He has never run from a challenge, and he will never run from this one. Instead, he takes these challenges head on. He moves towards them confidently with the assurance right is on his side. These are not merely words of his lawyer, rather than the action of Mr. Combs over the last several months conclusively proved this. Aside from his actions since the inception of the investigation, Mr. Combs' character is shown through his demonstrated contribution to society in several important areas. First, he has given generously over his entire life to charitable causes. To name only a few examples, since founding Bad Boy Entertainment in 1993. Mr. Combs has actively supported and donated millions to after-school programs and organizations like the Boys and Girls Clubs of America. His commitment stems from the positive influence such programs have had on his life, inspiring him to give back to similar initiatives. He's also supported organizations including the National Foundation for Teacher Entrepreneurship, further emphasizing his dedication to creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he with a partner opened Capital Preparatory Harlem Center Charter School in 2016 to provide high quality education to the inner city youth in New York City. The success of this initiative led to the launch of Capital Preparatory Bronx Charter School in 2020. Combs donated $1 million to support its development. These schools are part of his broader commitment to education, which includes significant contributions to historically Black colleges and universities, such as a $2 million to Howard University and a $1 million to Jackson State University in 2023. Mr. Combs has also been proactive in health and disaster reliefs, having raised over $2 million for New York City public schools and hosting virtual dance-a-thons that raised more than $4 million to provide personal protective equipment to healthcare workers on the front line of the COVID-19 pandemic. Particularly important in the election year, Mr. Combs' contribution to mobilizing young voters with the vote or die slogan through Citizens Change, which he founded to significantly increase political awareness and youth voter turnout. Second, few people have done more to advance the cause of Black people in the music, entertainment, and fashion industry as Sean Combs. Okay, Sean. While he has always been controversial, he has also always championed minorities and underrepresented communities. As chairman of Combs Global, Mr. Combs has used his platform to create the Excellence Program, an internship initiative with Endeavor in July 2021, a major initiative designed to provide development opportunities for aspiring executives in entertainment, marketing, music, and fashion from underrepresented communities. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network in 2016, the Superhero Award from Room to Read in 2017, the Child of America Award from the Carver Foundation in 2018, and in 2023, the Icon Award from the Apollo. Through his multifaceted career, Mr. Combs has not only created thousands of jobs, including valuable internships for young professionals, but has also supported minority and women-owned businesses, leveraging them as key supplier and vendors for his enterprises. Council will be prepared to address the factors of dangerousness to the community and weight of the evidence to court at the 2:30 p.m. initial appearance. The proposed bail package addresses any issues with flight and danger to the community. In light of the proposed conditions, the action Mr. Combs had already taken during the investigation, and Mr. Combs' lifetime commitment to live up to his obligations concerning every challenge that he's ever faced, he should be released to fight this case in court and prove his innocence. Sean Combs has never evaded, avoided, eluded, or run from a challenge in his life. He will not start now. As he has handled every hardship, he will meet this case head on and will work hard to defend himself, and he will prevail. Recognizing that a bail hearing is not the time to defend the merits of a criminal case, it is relevant to bail. The defendant has been made a clear commitment to defend an eminently defensible case. This is such a case. Finally, several courts in this district have recognized that the conditions at the Metropolitan Detention Center in Brooklyn are not fit for pretrial detention. Earlier this summer, an inmate was canceled from the timeline. At least 4 inmates have pruned themselves from the timeline in the past 3 years. Numerous courts in the district have raised concerns with the horrific conditions of the detention center, and they go through all the little different areas. Courts in the Eastern District of New York have shared the same concerns. The court noted that it was worried about the Manhattan detention center conditions as one of the reasons for the sentencing and the defense in a non-custodial case. So, in conclusion, for the reasons set forth above, we move this court to release Combs under the conditions set forth above. Thank you for your consideration. And they go down here and they have different things and stuff like that. So, what are you all thinking? So, this is the initial information provided to the court by Puffy's lawyers to sway the court into allowing him to bond out, which initially failed. All right. So in my next video, I'm going to go over the appeal letter, and I'm also going to go over the Southern District of New York's letter to keep Mr. Combs in the jailhouse. All right. Y'all, we do this every week. Please like, comment, and subscribe. Please share this video if you care. Also, make suggestions to me. Do you want me to do these readings out live on live, or are you okay with these recordings and things like that? Y'all, let me know down in the comments. I really do want to know. Again, thank you so much for watching. Thank you so much for watching. Please tell a friend, tell a kin, tell the coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people. Bye-bye.